America's working class has been cheated. That is an assertion.
Open border coordinate. That's a Koch brothers proposal.
And the Democrats jumped right on board with the corporatists. They got in bed with Wall Street, military-industrial complex, the fossil fuels, Silicon Valley. And now look what happened to the country. We have the biggest income disparity since the Gilded Age. Bigger than that. There's more.
Expanded trade has thrown the working class into much more competition than they experienced before trade with lower wage countries took off.
Can say is that as a country, we have to make a different set of choices because the choices we've made have hurt working people.
Congressman, because I wouldn't know what to tell you to write. I don't know what to do about the depression and the inflation and the Russians and the crime in the street. All I know is that first, you've got to get mad. You've got to say, I'm a human being. God damn it. My life has value.
Hello, and welcome to another Institute for Sound Public Policy podcast. I'm your host, Kevin Lynn. I'm also the executive director of the Institute and the founder of U.S. Tech Workers. And today is October 10th, 2024. And we have an amazing guest with us here today. And he is Daniel Kotchen of Kotchen and Lowe attorneys. And he has just prevailed in an amazing case that's known as Cox versus Cognizant, but was an amazing verdict that was reached against Cognizant, a Indian-based H1B visa dependent consulting firm. So without any further ado, Daniel, welcome to the show.
Thank you, Kevin. Glad to be here. Thanks for having me.
Well, it's great to have you here. So for those of us who may not be that familiar with you, Daniel, or your law firm, Kotchen and Lowe, you're a small law firm. And I want to give a quick bio of you because I think it's important. I mean, when you look at the people that have been engaged over the years in pushing back against the abuses that accompany these employment visa programs like H1B, optional practical training, L1, EB1 now is being abused. It's pretty amazing. And you guys, you have such amazing stick-to-itness, courage, and frankly, resilience. And ultimately, it was great to see you guys prevail in this case. And I know there's other cases you have in front of you. So a little bit for our audience on you. Daniel is a partner with Kotchen and Lowe, LLP. His main practice areas include complex commercial litigation, counseling, and representing clients before governmental agencies. In private practice, Mr. Kotchen has taken leadership roles in a number of complex commercial litigation matters in a wide variety of substantive areas, including antitrust, employment, fraud, and class action claims. Mr. Kotchen has successfully represented defendants against claims in excess of $1 billion and plaintiffs in cases resulting in settlements of up to $220 million. Mr. Kotchen has developed expertise in antitrust and has previously served as a trial lawyer with the Federal Trade Commission. Mr. Kotchen is currently litigating several large class action employment discrimination cases, including cases alleging the defendants predominantly employed H-1B visa holders as a means of discriminating in favor of a particular race or national origin. He's represented clients before the FTC, Department of Justice, Federal Bureau of Investigation, Department of Transportation, Federal Energy Regulatory Commission, and the state's attorneys general. He was selected to the Washington, D.C. list of super lawyers in 2018 through 2024, so 6 years running. Mr. Kotchen grew up in Lexington, Kentucky, and Morgantown, West Virginia, enjoys politics and sports, and is married with 3 children. Again, Daniel, so great to have you here today.
Thank you, Kevin. I appreciate it.
Wow, fantastic. So, I want to share, I knew, for instance, that the trial was ongoing, and I learned of it through Ethan Barron wrote an article in the San Jose Mercury News, and in it he described the cases. Well, the headline read, H1B visa company supplying thousands of tech workers to Silicon Valley discriminated against non-Indians, jury finds. Then he goes on briefly to say a company that supplies thousands of workers to Silicon Valley's technology industry and other Bay Area employers intentionally discriminated against non-Indian workers, a jury has found. So I'm pretty much going to turn this over to you now, Kotchen, and tell us, how did you get to this verdict? This is amazing. How long have you been working on this case? And how did you get to final it? And I know you've had other class action suits where you didn't prevail. Some of those I covered very closely, but tell us the story here, Kotchen, or Daniel.
You can call me either.
It's funny because I do have a friend named Kotchen, interestingly. And so I kind of
sounds like a great guy. So we filed the case in 2017. It was a long case. It was a difficult case. We, in any case, there are procedural hurdles that you have to get through. The first is something called a motion to dismiss that you have to get through. And then you have a class certified. There's a class certification process. So in this case, the class that was certified is a case of non-Indians, non-South Asians who were put in unallocated status, referred to as being benched and then terminated. And the class period was September 2022, I think September 17th, 2022 to October 27th. I'm sorry, September 17th, 2013 to October 22nd or October 27th, 2022. So from September 2013 until October of 2022 was the class period for folks who were benched and terminated that were non-Indian, non-South Asian. So after the class was certified, we had an initial trial. That trial occurred in June of 2023. And in a trial, in a jury trial like this, the decision has to be unanimous. And at the end of that trial, we had the jury in our favor 6-2, but it wasn't unanimous. And so that was a mistrial. It was declared a mistrial. And so we had the trial that we just completed, started on September 24th until last Friday, was the retrial of the case. And we were able to achieve a unanimous jury verdict, which we were obviously pleased about. And, if you were in the courtroom and you saw, I think, the evidence that was presented, it is a case that was, a strong case of discrimination. And any discrimination case like this is called a pattern or practice case. Typically, the starting point, and a lot of times what is ultimately dispositive, are the differences in treatment of one race versus others, one national origin versus others. So you have to look at patterns in the data. What did the data show with respect to employment outcomes? And when you saw the employment outcomes that we presented to the jury, it was a very, very strong case of discrimination. That's in a pattern or practice case. When you're dealing with class-wide discrimination, you're looking primarily at employment outcomes, and we had strong results on those.
Great. And for instance, one of the things we posted on X was a French citizen on a green card with a PhD in computer science witnessed the company's preference for Indians on visas. The lawsuit claimed. For instance, he said his name, Franchetti, with a PhD in computer science, was hired in 2007. And in his 9 years at Cognizant as a director and executive, witnessed the company's preference for Indians on visas, the lawsuit claimed. When he secured new business for the company, his manager would staff the client projects with visa-holding employees from India rather than non-Indian members of Mr. Franchetti's group, who were already in the U.S. and available for this work, this lawsuit alleged. So is that the kind of pattern and practice you were referring to?
Well, certainly that Mr. Franchetti, Dr. Franchetti, very smart, capable person. I mean, he was someone that was in his specific situation, he was a manager. So he oversaw other folks, and he testified to this, that he saw what was happening with respect to individuals that were not preferred being placed on the bench and terminated. He complained about it and he got fired. It was in our view, and the Equal Employment Opportunity Commission agreed, it was an act of retaliation.
Gotcha.
The pattern or practice, the specific results that we were trying the case over and what we were litigating primarily were the practices of Cognizant had mechanisms to source individuals in its preferred group. So it had a cultural preference to prefer Indian nationals of South Asian descent. And it used the visa program to do that. It had other means to achieve that talent, to source that talent group. Once it did, individuals who were not preferred, that were working in jobs, were rotated out of jobs, replaced, had to train folks a lot of the times, put on an unallocated status referred to as being benched, and then were fired. And so that was the specific patterns that we presented, where we had shocking disparities from, we're doing statistical analysis where folks who were terminated from the bench. And so individuals who were not Indian, not South Asian, were 8.4 times more likely to be terminated from the bench than individuals who fit the preferred category, the Indian nationals. And in discrimination law, this dates back to a Supreme Court case from 1972 referred to as Teamsters. In Supreme Court law, when you have a disparity of that magnitude, that's evidence of intentional discrimination. And that was what we presented to the jury, along with a whole host of other stuff that was perfectly consistent with there being a favoritism and preference for one type of person employed in these roles. That was what we presented to the jury, and it was accepted.
Right. Was there a point in the trial? Now, how many days? I knew someone who had provided expert witness because he had mentioned he was going out to LA for that. Question: was there a time when you felt that you had the jury in this, and you just kind of knew it, you felt it?
I will say this about jury trials. Jury trials, they're risky. And so go back to our initial trial, which was a mistrial. I mean, we had strong evidence there, including, strong evidence of disparities, but you had two jurors who just didn't, you poll the jurors after the case is over, you can talk to the jurors. And they were so mad at these two who just wouldn't engage on the evidence. So all it takes is one person to kind of, because the verdict has to be unanimous, it takes one person to kind of force you to go through the process again. We felt very comfortable in the case we presented, but you never really know until you get the actual verdict how it's being received. When you're trying a case like this, you have to take every precaution. You want to stay away from the jurors. You see them in the courthouse, you see them in the cafeteria, you could be checking through security together. You want no contact. We made every effort, and same with Cognizant lawyers. Everyone's is kind of on the same page. You just want the jurors to hear the evidence and react and make a decision. We felt strong about our case, but you never really know until you get the actual verdict.
Right. Now, what were some other, you had mentioned in it, you had laid out the practices. What were some of the other interesting things that you presented to the jury that you think our audience should be aware of?
It's when you look at the data and you see the practices, it's in many ways it's heartbreaking to me, because I started my firm with an orientation to the working class, to just normal people, labor. And so you see the data. I mean, there's one witness we presented. She was the first witness that we presented. Her name was Abigail Israel. And she was the head of Cognizant's affirmative action efforts. So Cognizant is a federal contractor. So they do work for the federal government. That means that they have affirmative action obligations they have to undertake in order to do that business. She headed those efforts. And her testimony and analysis that she was involved in and presented with when she was at Cognizant, and then instructions she received from leadership not to share data, it's striking at how much was known about the business practice and the efforts from our perspective taken not to share it, not to disclose it, to keep it under wraps. That's how we interpreted the evidence. That's how we presented the evidence. So I'll give you for an example. There was one analysis that Miss Israel, she was the keeper of the race data, provided race data within Cognizant. And you look at the data, and that data shows if from a snapshot, 8 months in 2018, okay? And you look at the data, and it showed termination rates by race. So the Asian category includes South Asians. These are the race categories that are reported to the EEOC. So Asian categories include South Asians.
So there's not a separate for Southeast Asians, Northeast Asians, and East Asians. It's all lumped together.
It's all lumped together, and the evidence reflected that this was predominantly South Asians, the Asian category. Mm-hmm. The termination rate by race. So in first 8 months of August 2018, this is what the analysis showed, was 1% for Asians. Okay. For Black,
and that's not just Indian Asians. That's all the Indian bloc. Just 1% on the terminations.
Right, but predominantly South Asian, right? Indian national origin, predominantly. Mm-hmm. So you take that 1%. You compare it, for example, with Black employees. Black employees were terminated at 27%.
Wow,
at a 27% rate. Hispanic employees almost 20%. White employees at 9%. And so you look at data like that, and you realize that just based on the data alone, it looked like that there was differential treatment depending on which racial category you fit into. And that's where it becomes so disturbing to me, where you think about, we've done a lot of work in discrimination. We're representing Black employees at a wholesaler in Connecticut. And you look at the data, and it's so disturbing to me that you have that kind of outcome, that disparate, depending on which racial category you fall into. I don't know of any way that you could ever justify outcomes like that, except if you're making decisions based at least somewhat, if not largely, on race. And that's why what the discrimination laws are designed to prevent. It's why the Teamsters framework, which was a genius framework. It was such a well thought through framework from the early 1970s.
Can you describe that framework for us if you haven't done so already? Sure.
So that framework is if you want to prove intentional discrimination and you're looking at it class wide. Okay. So you're looking at it is a evidentiary framework that applies only to class actions. So, but by and large to class actions. If you're looking at a national practice, you have to look at what the outcomes are. What does the data show with respect to outcomes? So if there are, if you see termination rates, termination differences of that amounts to 2 standard deviations, that means that there's only a 5% chance that the differences in treatment based on terminations, if you're looking at, for example, termination rates of Black employees over white employees or white employees over Black employees. If there's 2 standard deviations, that's an inference that 5% chance that outcome was a 5% likelihood that was a result by chance. Discrimination probably factored into it. Those are basically how you look at whether or not there's discrimination, intentional discrimination in employment practices. Look at a specific employment outcome. In this case, the standard deviations that we presented that were unrebutted by Cognizant were 75 standard deviations, not 2, 75.
75, 2 versus 75.
75, that means that the likelihood that you see the difference in treatment by race with respect to bench terminations was less than, could it be by chance? There was a less than 1 in 1 billion likelihood it was by chance and not the result of discrimination. It was such powerfully strong evidence of discrimination. And that's basically what the Teamsters framework started in the early 1970s. You know, it's funny because I don't want to get on my high horse here and talk about. Are you there, Kevin? Or do you freeze out?
I heard your audio was coming through fine. Your image froze a little bit, but the audio was fine.
Okay, your image is frozen to me, but it's frozen on a good look for you. So I think you're
okay.
You're looking good to me. You're just frozen. I don't want to get on my high horse about discrimination, okay, or about, you know, we've talked so much about the dysfunction in Washington and Congress, right? We have some really good laws on the books. There are some really good laws on the books. The discrimination laws are really good, and they're not being consistently enforced, and that is a real problem. And while we're on the subject, there's one more thing I'll say on this that's highly disturbing to me about where we are. Included in our class are non-Indians who were benched and terminated, right? Those are the people we're representing, except for those people that signed arbitration clauses. If you signed an arbitration clause, you're out. And that's the law. And that comes from a Supreme Court decision referred to as Concepion, where the Supreme Court has made the decision that arbitration clauses between employees and employers have to be enforced. That means you cannot pursue a case in federal court, in open court. You are confined to arbitration, paid for by the employer, and there are going to be if there's a class waiver in the arbitration clauses, which there always are, that means you cannot avail yourself of the class action framework. So what does that mean as a practical matter with respect to employees, normal people? They can't avail themselves of the Teamsters framework. That framework's out because that's only applicable in the class action context. It is a horrible, horrible decision that materially affects individuals to protect themselves against sophisticated corporations. If we'd had arbitration clauses consistently through the class period, there's no way we could have presented a case like this. We would have been out. And that would have been so sad because it meant that a practice that I view as abusive and contrary to the interests of the working people never would have been brought to light, never would have been tried. It's something that I think your listeners need to know about, and they need to think seriously about how important it is for working people to avail themselves of every opportunity to push back against corporate practices that abuse them. If you're someone that's looking for a job and you're not willing to sign on to like the employment contract with an arbitration clause, the likelihood that you're going to get that job is reduced substantially. Employers, by and large, make people sign arbitration clauses, and that's a condition of employment. And so, for the Supreme Court to reason that clause reflects a meeting of the minds, a bargaining of two parties that have equal bargaining power, I don't agree with. I think it's
because you're desperate to get a job, you'll sign it. I will. So now, question: they may not be able to avail themselves of a class action suit, but could they sue individually?
Well, if they sign an arbitration clause, they can't sue in open court. They can arbitrate. So that is a process that's done behind closed doors. So nothing becomes public. The process is funded by the employer itself. And then, an effort, you look at what we just went through in this Cognizant case. It was a Herculean effort to get to a jury and to win a jury verdict. It took years, 7 years of where you are spending so much time, effort, and resources in it. You can't do that if it's just one individual representing just his or her own individual circumstance. You're not going to have the discovery that enables kind of what you need to show a pattern or practice. That took years. It took years of backbreaking work to develop. And so you can't do that for single individual cases. You can only do it if there's a mechanism by which claims can be grouped together, can be aggregated, so they all can be redressed in one proceeding. And the Supreme Court's decision forecloses that. It is a corporate-friendly decision where the normal people, labor, is being put at a disadvantage. And it's such an offense to me. I can't take it.
Wow. Wow. I mean, it just diminishes the size of your potential pool. And I
Right.
recall,
And importantly, it also, what it more, perhaps more importantly, it enables dubious practices to persist, where
Mhm.
workers are, is, if corporations, if employers that are suited, if they're going to engage in dubious practices, they're not going to fix it unless a light is shown. There's a bright light shown on it, and so that's the benefit to corporations of that provision.
Gotcha. And probably not a lot of chance of things changing because that is a ruling by the Supreme Court, as you mentioned.
It's God. I hope it changes. I hope it
Hmm.
changes. It needs to change.
Wow. Absolutely. And in these cases, I'm sure I don't think the transcript of Cox versus Cognizant is available, but back in 2018, there was the other case that you were part of,
Yes.
uh, Buchanan versus Tata Consultancy Services.
Yes.
And it was because you're talking, these large data models that you're able to use. But when you listen to the testimony of some of those people, like one woman who had been working at, I believe it was SoCal Edison, and she was rebadged to Tata,
Hmm.
and she had been doing that job for years, and she's working for Tata, and she goes into a meeting and corrects them on things. And then afterwards, she's told, oh, don't speak up in any more meetings.
Yeah.
We don't tolerate that. I mean, and before you know it, because they'll suck the knowledge out. I've seen it again and again where you have these situations where they will either rebadge. The whole idea is to do the knowledge transfer, whether it's done, lording over you with the 6 months of pay of severance pay to train your replacement, or will rebadge you like they did at CSX Railroad and Vanguard Securities, where you're working for Vanguard one day and then Infosys the next. But people have to understand it, and which is the beauty of this verdict in this case, is you demonstrated where eventually, after they've sucked the knowledge out of you, they'll put you on the bench. Is that correct from what you saw in this case?
Well, I mean, sir, there was a witness named Christy Palmer who testified here to a similar scenario as what you described from the Tata case. And so, I mean, the evidence that we saw in this case is that there was certainly, I mean, Christy Palmer testified to a knowledge transfer process where she was replaced by folks that were rotated in. She trained them on their positions. Then she was out and she got put on
Mm-hmm.
the bench. And then she had to go and find new work for herself, which, I mean, she ended up doing, but then it became too much. She ultimately left. We saw evidence of kind of a rotation policy of where one individual who was visa ready, I'm assuming you know what that term means. It means if you have a valid visa that enables you to travel and work on a moment's notice in the U.S. Visa ready individuals were rotated into roles. Other folks who are working in roles were rotated out of the roles. And those folks, if you're rotated out of a role, there's only, unless you're placed immediately in a new spot, you're going to go to the bench by and large. And
Wow.
that's what the evidence that we saw. The data backs it up with respect to who got terminated from the bench once they were on there. So that was some of the evidence that we presented.
So, what other advice can you give to tech workers out there, anyone in the IT sector, because they're all impacted? An amazing statistic: in 2023, we only created 700 net new jobs in the IT sector with all the firings, and take the
Mm-hmm.
firings from the hirings. And
Right.
yet we still brought in over 120,000 H1B visa, foreign H1B visa workers. So here, this sector is hemorrhaging employees, and we still bring in foreign workers. I mean, these are really difficult times to navigate for those who are left in this sector. Is there any advice you can give them? We used to call it, what do you do when you're going to be H1 booted? What advice could you give to workers here in the 2024?
It's funny. Well, it's not funny, but it's in fact sad. Look, my advice is to speak out. It takes extraordinary courage. Let me tell you a little story. Okay. We got into this work in 2010. We represented H1B employees these employees are an incredibly vulnerable group of individuals because they want to be, they're brought into the U.S. The people we were represented were affirmatively lied to, brought into the U.S. They didn't have work. They were put on and they were said, if you want to go work, get paid, you go find us work. If they complained, they're deported. And so what I would recommend, and anyone impacted by these dubious practices, excuse me, something just popped up on my computer. I got to exit out. They should stand up if they can. They should complain. And I would say that for individuals who in the tech sector who feels like they're the victims of discrimination, those individuals who see a preference for one type of employee, they should speak up as much as they can. Individuals the visa employees, there's so often we hear stories about how mistreated they are. And that's equally as offensive to me. If they can come forward with their own stories, it's helpful to shine a light on what's going on in the industry. I think it's a business practice that is benefiting corporations. And there are the normal people, the labor, those who are preferred and those who are non-preferred are both being impacted in a bad way. So my advice is speak up. It's important that individuals who are, making policy, people who are enforcing laws know what's happening and what the effect is of these practices. So often there's debates about this, and the talking points from the major corporations just sound so good and so smooth, but they happen to be very, very incorrect. And there's not a STEM shortage that justifies this behavior. There are good people being displaced from good jobs that have worked hard to get in the positions that they're in. I get calls all the time. Literally every day, I feel like I'm being inundated with calls, and every story has a commonality. It's someone saying, I've worked, I'm doing a good job, I'm out. The people that don't call us, that I wish would too, are the H1B employees or the visa employees who are also being put under the gun and treated in harsh conditions and working in ways that we're not accustomed to seeing people work in the U.S. And so anything that can be done to shine a light on this is worthwhile. Every voice matters. You should speak up and try to draw attention to it. It takes courage, and it's really hard to do.
Yes, it does.
But it's worth it.
Absolutely. I want to go back to, you had mentioned the law and policy. What's the gap between the protections the law affords and what's the policy? Why, we do have good laws on the books. Can you enlighten us, Daniel, as to what's the gap there? Why can't we seem to enforce to the letter of the law?
It's I thought a lot about this. It's interesting where we are as a country. And I see this as a symptom of something much bigger and of where we are. Law, this is my view, okay? So it could be slanted. There'll be a lot of people that don't agree with it. Laws are not being enforced. Law, if you are a sophisticated corporation and you're a donor and you have resources in a lobby, you are protected in ways that never would have occurred 20, 30 years ago. It's the practice of law is an interesting field because it's always shape-shifting, always. And what happened a lot of times as lawyers, when we're on cases, what we do is we brief precedent. So if there's a decision that came out in the 1970s, you're like, okay, here's a good precedent, judge, right on point. But there could be a lot that's changed just in terms of society and politically between now and then. And I see that happening now. And it's not just in this sector. In the intro, you talked about my antitrust experience. It's funny. I was born and raised an antitrust lawyer. That's my DNA. I'm an antitrust lawyer. antitrust laws. I mean, for the first time in a while, they're being enforced now. But for so long, there was no antitrust enforcement. Look at the consolidation that's occurred in industries. Look at how many airlines have merged without being challenged by the government. Look what's happened to prices in the interim. Why do you think prices here are so much higher than they are anywhere else? And it's because we don't have the protections that other industrialized nations do. And we should, because we're the leader. But when it comes to major corporations, laws are not being enforced the way they should. And this is what's happening in the tech industry. It's a symptom of it. It's you see what's happening in the tech industry. It's not isolated. It's happening in other sectors as well. And it's very discouraging.
Wow, amazing. We have, for instance, we know right now that the Biden administration, in the last few months, the last quarter of this year, they're planning 4 rule changes that will impact employment visas like the H1B. For instance, they're going to expand what the specialty occupation is. They're going to exploit a loophole that would allow a nonprofit or university to bring in, because they're not restricted by the cap of H1Bs, and then lease those employees out. There's things like that going on. So certainly at the policy level, they've been able to enact changes. Sometimes, like the optional practical training program is, if ever there was a case for deference, this is it. This was dreamt up by during the W. Bush administration by Bill Gates and Michael Chertoff, and there it is. No statute creating it or anything like that. So what can we do within the constraints of the law to push back against the bureaucracy when they kind of go off the reservation and start doing rule changes and enacting policies that seem to run contrary to the protection of the domestic workforce?
Well, I mean, look, I can't speak in any intelligent way at all about what's happening in terms of the last 4 months, what you talked about. I just know literally nothing about it. What I can say is this: there are laws on the books. There are federal agencies that are charged with enforcing the law. You have the Department of Justice, the Department of Labor, the Equal Employment Opportunity Commission, whole host, and whatever they're staffed with good people that have the mechanisms and resources to enforce it, but it hasn't worked. Not for a while. People are not, what I see, and this is, a voice of one, so take it for what it's worth. I see federal agencies that are interested in tackling low-hanging fruit, easy wins, without going after the hard work necessary to affect meaningful change to make sure that workers are being protected. And I see it, again, Department of Justice. I'm not going to share with you the discussions I've had with the Department of Justice over the years, but it's horrifying to me that I can't get over people that are so resourced and so intelligent that just don't seem to have fire in the belly to do something. And so meanwhile, we're a tiny firm. We effectively have 4.5 lawyers, just over 4 lawyers, that we're trying to do everything we can to make a difference and to protect people. It shouldn't be up to us. We have so few, there's so few of us. We have such limited resources. These agencies have extraordinary resources. They can do so much if they just had the right, if they had the right mandate, if they were pushed in the right ways to do it. They could do it. But they've made the choice not to. There was a fear, I think, of losing for so long that's probably shackled people. I think that's part of it. I think it hasn't been a priority for administrations for a long time to do some things that are meaningful. And I hope in the future it's going to change.
I do too. I can speak anecdotally We're currently in litigation now against 40 companies that had banded together, created a website that was literally called Chicago H1B Connect, where, I mean, if you were other than an H1B, and it was a website, companies like John Deere, Walgreens, University of Chicago, Illinois were on it. And you could go to their website, board, go and apply for jobs. And to me, that was outwardly discriminatory. And I'm on the phone, well, actually in a Zoom with someone from Department of Labor or actually Department of Justice at that time. And I'm going, and they go, well, Kev, these things are really difficult to prove. And I said, well, we've had 9 people who are the plaintiffs apply for jobs that they were qualified for. None of them got them. And then with one of them, we took a resume that had been flatly rejected, after they'd gone through the portal and filled everything out. And then we just simply changed the name on it to a South Asian name and didn't list the citizenship status. And they got a call right back, inquiring as to their citizenship status. So I'm thinking we have a really good case. And I'm talking with someone on this Zoom and they go to me, well, Kev, these are really difficult to prove. I mean, and I'm like, excuse me, what if the site had said Chicago White Connect? Now, we'd all agree that that would be kind of discriminatory, right? So, we're arguing, collusion and conspiracy, and, we're getting some settlements, but yeah, that's the kind of stuff, that's what I keep getting when I approach the agencies, what I'm finding, and it kind of mirrors what you're saying.
Right. I mean, it's like, I think to do stuff that's meaningful, there is a risk of losing for sure. It is hard work. And the agencies, I just, again, it's not just this one issue. It expands a lot of different industries and a lot of different sectors. And, I hope that change could come about. I really do.
Yeah. And you have me thinking too, because you've said this is something that, we're going back a few decades on. And so maybe, as you're saying, they've gotten comfortable with this change in attitude. But at the same time, this is where a new presidential, I know I'm waxing political here, but a new administration could come in and they appoint about 4,300 people. Now, oftentimes it's kind of like the tail wagging the dog. But if you can appoint key people and key advisory roles in these agencies, and they really adopt an America first, where we're going to make sure that, we take care of the American worker prior to, foreign workers. And we don't like the notion of indentured servitude. That could probably, I would like to think that will help a lot. It might help you in your future cases, and it would certainly help us in, putting policy that actually works in favor of the American worker.
Well, I mean, here's my take. I mean, I've been doing this long enough. I think that these agencies, the federal agencies, are staffed with very, very capable people. I think the people in it, like, I used to work at the FTC. A lot of my closest friends still work there, and what they're doing is laudable. Like they're public interest oriented, or else they wouldn't be working there for all the time. I think agencies are staffed. A lot of times, what I feel like is when you have leadership coming in, and it's explicitly directing folks not to do things, not to focus on certain things. I think that's a lot of the problem. So for the existing federal workforce, like when I meet people that have been with the FBI for years, FTC, DOJ, my heart is with them. It's when it's at the top, and I'm having debates about things that I care about, and I'm getting pushback in ways where I think that there's not sufficient protections for people, normal people, everyday people. That's where I start having issues.
Right. And I absolutely agree with you there. I think these are really important things to consider. I mean, this is the Leviathan in a way that we're fighting, that's grown up over the last 4 decades. And I think it's all kind of based on this globalization, cult of neoliberalism that only seems to focus on the maximizing profits as we move capital and people around the globe. So,
I mean, look, I brought up the Concepion case. That's about arbitrations. There's another case from the Supreme Court that's along the same lines, which is called Citizens United, where that is basically, protected the unfettered and unlimited donations to political action committees as an exercise of free speech, which is so contrary to me to anything that represents what normal people in democracy should be working towards. And so I agree that there's an effort to protect corporations above others, normal people, working people. And that's where I have a big issue. And that's where I see all of this to me in my own mind. I may, I'm no authority on any of this. I just kind of, these are my own thoughts. I see a connection between it all.
Yeah. Dan, we're coming up on our hour. I kind of see you as a kindred spirit of mine out there. And I want to ask a personal question. What motivates you to do this? You're one of DC's top attorneys. There's probably far more lucrative things you could be doing, but what puts you here defending the public interest day in, day out?
It's funny. I'm a DC lawyer, I guess, but I live in a tiny town in Wisconsin, a town called Neenah, which is an absolutely fantastic town. You should come visit us. Wisconsin's a great state. Neenah's a great town.
Okay.
Look, I did the big firm thing. I was representing Big Oil. I was, representing Philip Morris. It's not my cup of tea. And so I wanted to do my own thing where I'm fighting a good fight. Money has never been a priority for me ever. And if you saw the way I live, you would see that. It's just not a priority. I don't care. What I do care about though is seeking justice. It's an absolute privilege. I mean, honestly, an absolute privilege to get up and do the work I do every day. And if you saw the people that work with me, we share it. It's just something that is different. We feel like we're making a difference. We have courage. We're not afraid to lose. We will take on the tough issues, even if it means that we can't prevail, as long as our passion's behind it. That's what I find motivating. Come see me and we'll talk more about it.
Wow, fantastic. So, Dan, how can people get a hold of you? How can they find you? How could they keep you informed of what's going on, their workplace, see if you can help them with a grievance?
You know what? It's just go to my website, www.kotchen.com. Family motto, it's like kitchen, but it's with an O. It's Kotchen. So it's an easy way to remember it. I wish I get so many calls, and I wish I could bend over backwards for absolutely everyone that calls me, and people that have talked to me know that I'll help them, even if it's just kind of thinking through options.
Gotcha. Well, before you go,
okay,
want to as a way of showing our appreciation for everything you're doing.
Yeah,
we'll be sending you along a cap for the Institute for Sound Public Policy.
Always can use more baseball caps.
There you go. And also we'll send along a U.S. Tech Workers coffee mug. I've been drinking from it.
I can't wait. I'm a huge coffee drinker. I drink two things. I drink coffee, and then at 5, I start drinking beer. That's the way we do it in Wisconsin. So okay. A lot of times it's before 5 we start drinking, but when it's 5, we're definitely drinking.
Fantastic. Also a coin. It says disobey. And
I like it.
It is by an amazing guy who has a site called Silver Shield, Silver Bullet. And okay. he is all about, pushing back against what he sees as an out of control Uber government. And okay. Then lastly, and you'll see me wearing it, I'm probably the only one in the country that still has these. This is a pin from my Ross Perot days. So after Ross Perot had run in 92, he formed a group called United We Stand America,
Okay.
which was purposed to do kind of what you and I are doing today,
Okay.
seeking justice for American workers, putting America first before the term was cool. And so you'll be receiving that as well. And
Good.
for our listeners, before I sign off, we got a couple of big things coming up. Next Wednesday, we are doing a webinar. After a lot of work, we are releasing our semiconductor report, which is labor practices in the 20th and 21st century for the semiconductor industry. And it's coming out at what couldn't be a better time, because here we have the government, through the CHIPS Act, providing billions of dollars to companies to enhance domestic production of semiconductors. However, at the same time, they're laying off their domestic workforce, and they've been investing heavily in bringing in H1B workers, OPT, L1s. So the report it'll be done virtually. It'll be about 2 hours after we drop the initial report. We'll be joined by Steve Peralta, who had worked at, he's a whistleblower who had worked at Intel for 9 years. We'll be joined by Dr. Pamela Denise Long to tell you how we can get an American first oriented labor workforce off the ground. Also, John Fear will talk about the optional practical training program. He's from the Center for Immigration Studies. And then I'll close out talking about the H1B visa program. And then lastly, my dear audience, on the 15th, we will be launching our annual fundraising drive. So if you enjoy videos like this, if you enjoy the work we do at US Tech Workers to not only identify what's going on out there, but also push back against it, think about donating. We got a really cool video we're going to be launching, so enjoy. And then in closing, I just want to say again, Dan, thanks so much for your time. This was really fantastic. Love the work you're doing. If you need any help, please don't hesitate to reach out.
Thank you for your interest, Kevin. I appreciate you having me on.
Thank you.